this. If we need to upload it, we will be able to do that at a later point. But we're going to be good to go. So
Right.
let's just go ahead and proceed.
All right, Mr. Hutton, do I need to read the conflict statement once again?
I think you're still good since we have already convened the meeting. I think everyone's aware of their obligations and the need to point out any conflict if there is, or to avoid a conflict of interest. Feel confident about that. This is a very ethical group of people we have here.
Brian, do you want to start with the staff presentation, or do you want me to give an introduction?
Yes, I will. Oh, and it looks like the stream is now working. So, welcome to anybody who's joining us on YouTube. I know there's a lot of interest from folks. But we want to go ahead and start off just with the general description of this, the introduction of this particular inquiry. This is a matter that we've labeled inquiry of staff, and we've done that because we've received a number of inquiries over the years on this particular scenario. The scenario being that laid out in the introductory memo that was in the April 2025 Ethics Committee materials. And it really is, it consists of a fairly straightforward scenario that gets very, I think, potentially complicated once we start getting into the analysis of the different professional responsibility obligations. But the scenario is simply that we've got an attorney who is a real estate attorney, closing attorney for residential real estate, and is a partner in a law firm. And we have another attorney that's a partner in that same law firm that owns a financial interest in a title company. Whether it's a financial interest or maybe they serve as an agent of that title company, I think all apply there. But we have a couple of different inquiries in the introductory memorandum. The first being that a client retains the attorney who has a financial interest in that title insurance agency. And the question being, if that client retains that attorney, attorney B, we'll call the attorney B the attorney that has the financial interest in the title company. If a client retains attorney B for closing, can attorney B prepare a title opinion to obtain title insurance from the title company that attorney B has a financial interest in? And that's kind of a restatement of a question that I think has been addressed in prior opinions, but I think it's appropriate for the committee to look at that again in light of just kind of the current environment, really, because a lot of these opinions that deal with these types of ownership interests, they date back quite far, a couple decades ago. So that's the first question. The second question was the client retains attorney A, the first attorney I mentioned in the firm does not have a financial interest in that title insurance company. And the question being, well, attorney A in closing the transaction for the client, can attorney A prepare a title opinion for obtaining title insurance through the title company that attorney B has a financial interest in? That's going to call into question the imputation of conflicts that we have in the rules, and we can get into those details a little bit later. And then the third question that was posed by the memorandum was, does the answer to that question that I just posed, does that change if attorney A is an associate as opposed to a partner in that law firm? Now, I want to take a moment to say that the origin of these different scenarios, like I said, we have received questions throughout the years on this type of scenario or some sort of variation of this scenario. And it's something that I think on staff, as we saw kind of maybe I would say a renewed interest in this question, particularly with regards to the imputation of conflicts. That if your partner has a financial interest in a title company, can I, the attorney who doesn't have that financial interest but is partners with somebody who does, can I just send business over to this title company that my partner is going to be receiving some sort of financial distribution, whether it's a dividend or something like that. It may not be a straight commission, but there's some sort of financial interest in that regard. And so we've had these questions come up. We've had different folks that have approached staff counsel at CLE presentations about this scenario. And it seems like there's kind of two sides here. There's either absolutely you should be able to do this, or absolutely not. This would be just a horrible thing. And so we're kind of stuck in this spot because we also have this question. It's not just a question of if there's a conflict. We first have to answer the question of just the general notion of, is it a conflict for an attorney to say have a financial interest in a title insurance company and close a real estate transaction while basically referring business to that title company that they have a financial interest in. Like I said, that question I think has already been dealt with by some of our ethics opinions. We can talk about that, but our ethics opinions differ from some other states, and I provided. I know, just as by ways of background, I provided both North Carolina opinions that are relevant, but also an opinion from South Carolina, as well as an ABA opinion from, I believe it was 1972, that addresses that reaches a different conclusion than North Carolina has reached. So we've got that question, but then that subsequent question of if we're not talking about the attorney, him or herself, that has that financial interest, it's really their partner that has that financial interest. Is there an imputed conflict? Presuming, if we say that the answer is yes, there's a conflict, is that imputed to the other members of the firm? So we have a lot to discuss here. Like I said, I feel like they're kind of straightforward questions, but the issues are very complicated, and there's a lot of interest from the profession, and just I'd say the real estate. The real estate scene out there. Title insurance companies have contacted us, or representatives from title insurance companies, as well as individual lawyers that would like to be heard on the matter. But for now, I think this first meeting, it would be good just to kind of get our bearings and see exactly how the committee wants to proceed in terms of addressing these different issues.
All right. Thank you, Brian. At the end of the April meeting, I talked to a few people informally. They were all sort of skittish that this ought to be allowed and felt like maybe this had been answered in prior opinions, but I think the issue is a little more nuanced than that, and we want to make sure that we get it right and hash it out fully, since there's so much interest within the bar and then also with some other interested stakeholders, such as the title insurance companies. So I'd like to open it up to anyone who does have the opinion that maybe we should follow the course of sister states and allow some of this, and maybe that'll help spark the discussion. Does anybody feel this? Either one of these would be should be allowed.
Judge, I have a question that is probably embarrassingly basic, but for the people who are in favor of this being allowed, what's in it for the public? I'm missing that. Why would we be doing a favor to the public by allowing this? Or is just this simply a question about whether or not lawyers could have a different way to make some other money? It's another side hustle question. So Brian, Judge, whoever knows, what's in it for the public?
I'm looking over at Craig right now because Craig is our dirt lawyer on this on this committee, and I'm sure there's other folks that are probably watching on the stream that have an answer. But I'd love to hear from all y'all. See, Martin, you've got your hand up.
I do, and Gina, I'm a dirt lawyer too in my other life.
I thought you might be. You're
Okay.
an everything lawyer. You're our everyman.
I swear I am a country lawyer. So one of the benefits that I would find in this, I'm not saying I'm in favor of it, but one of the reasons why you would sell this is there are all title companies are not created equal. They all charge equally as far as the rate is controlled by the state of North Carolina. It's set. So you can't do it based on, I'll get you a better deal. Sometimes the reissuance rates, they might be able to do a little bit with that, but not much. But what I'm looking for when I find a title company, and Craig can correct me if I'm wrong on this one, I'm looking for someone that'll work with me really well, and they may be willing to go a little bit out, a little further on that limb than some others will. Because some of them will be like, no, you've got to get this estate done, you've got to get this done. Oh, I don't care that it was 35 years ago that this happened. Whereas some say, oh, 35 years, nothing's happened, we're good to go, send it on. And so those, and I think where that would come into this situation is if that attorney X happened to be a member of that really good title company or owns some sort of percentage interest, even though I'm not going to attorney X to say, hey, what do you think about this? I'm going straight to the title company because they have an attorney as well. And so you're dealing with their attorneys to see and their staff, and then they'll run it by their underwriters to see whether or not going to insure it. But that seems to be the biggest thing to help people. And I can tell you there's a tremendous amount of pressure, rightly or wrongly, on the attorneys to close quickly. And I don't know what's happened lately now. It seems like it's been a darn full moon, but I've got several that I have old estates that have not been docketed, like say in Columbus County. They're exemplified copies in Wake County. And I don't know if you've tried to get exemplified copy out of Wake County lately, but they're telling me 7 weeks. And so I can tell you 7 weeks on a closing is like death. And so that's kind of a nutshell of why some title companies are easier to work with others. And that's why there is an interest in getting it to, say, a company that would do that. And so now if they're prohibited from using that company, then you got to go to another one that might not be as willing to insure.
Okay. So I'm again, probably a dumb question, but I'm assuming that it is a small number of real estate transactions who are going to get resistance from a title insurance company, and you might need to go find somebody who's going to write over a risk. Is that true or no?
It depends on that full moon that's out right now. I probably have about, out of the last 10 that I've done, I have, I think, 3 to 4 that I'm having issues with, which is unusual. I normally don't have this. But the other thing that's pushing against us, and we have to think about it, unfortunately, and this is not the law, but the way reality is, there's not a lot of availability of houses in certain markets. And so you have, I call the low-hanging fruit that's gone. And now people are trying, because they see these high dollars, you see these heirs who've never done anything with mom or daddy's property suddenly thinking that, oh my gosh, I can get that for it. Well, let's sell it. But they haven't bothered to take care of the back end of getting it ready so the title can be good. And that's happening more and more now. There's so much more pressure in southeastern North Carolina than there's ever been. The other thing that will come up, and probably it's just one of those things just for information, Craig knows it too, easements. Oh my Lord. That's been the biggest issue right now. Easements over farm property that was a soil road that great-great-grandfather Sam had. Everybody's used it. Everybody's related to each other. And now suddenly you've got an outsider that's come in and you've got one or two things are happening. Either the family's not happy with it, so they close the road, or the person buying is not happy, so they close the road so you can't get through their property to get to the back of it. And so you got to find a title company who's willing to insure over that mess too.
Okay.
Well, I'll say this,
That's kind of-
Gina. I think, I'm in a different environment than you're in. I don't have to deal with rural properties very often, but the title companies that I do business with are typically staffed with attorneys, particularly on the underwriting side. And that's really where you're driving here is the issues relating to problems, title exceptions, and how you deal with those. And there are definitely companies that, they're very experienced. They understand the issue of taking on risk, and some are much more amenable to kind of dealing with something or insuring over it. And that exists right now. That is just part of the landscape. And so there are probably 2 or 3 title companies that I use in Charlotte that are not affiliated with law firms, that are not owned by practicing attorneys in the real estate arena, but they are staffed by people who are licensed attorneys that have real estate background. And it works pretty well, to be honest with you. I'm not so sure that there'd be an incremental benefit to having a lot fewer restrictions on what you can do as a practicing lawyer as far as owning a title company or owning an interest in a title company is concerned. But it is a head scratcher. You're asking somebody, an unsophisticated client in many respects, doesn't really know chapter and verse of real estate law, and yet there's maybe another attorney under the same roof as the one that you're dealing with the substantive aspects of your deal, who has a pecuniary interest in getting a referral from their law partner. And to me, I don't see a benefit that outweighs the smell test that you could maybe undertake and say, this just does not seem right. It does not seem like this kind of, intra-law firm relationship that leads to a title premium and then a kickback, or not a kickback, but a economic benefit to one of the attorneys. That's just one of those things that's hard for me to process. I don't see the benefit of that. I think it's fraught with issues, and I'm not sure it really protects the public. I think it puts the public at greater risk, to be honest with you.
Hey, Greg, are you licensed in South Carolina?
No, but my firm obviously has offices in South Carolina. It's very different, Tom.
Can you give us an idea of how it works south of the border? Because that's what we're comparing ourselves to.
It's a lot less stringent. For instance, our own firm has a captive title company that's tucked up within our organization. And in essence, the South Carolina partners who have the ability to use this entity, they get a return from that. And that is something that's very different than in North Carolina. So you have attorneys who are working on a deal, and it's a firm-owned entity. And so that entity might issue a title policy, get a title premium for that, and then the proceeds stay in-house. So there is a pecuniary interest that flows to lawyers who are associated with and who basically deliver title opinions to that entity, and that entity then issues title policies for a premium. So it couldn't be more different, Tom. It's very, very different.
And is it generally the case in South Carolina where lawyers do hold financial pecuniary interest in different types of businesses?
Yes, yes. And I would think that if you're a firm of any size, probably in the state of South Carolina, you probably have that kind of arrangement where you've got a captive title company as part of your organizational structure.
And is this not unlike the kiosk in the lawyer's lobby?
Well, for those of you who weren't involved on that one, there are definitely similarities for sure.
Who knew the kiosk opinion would actually be relevant
In a real estate matter.
Well, Judge, so what we're hitting on here is one of the things I was curious as your staff counsel to this one. Who do you all want to hear from? It's like this, we kind of see the different sides. And I think the answer in North Carolina to that first question of can a lawyer have a financial interest in a title company that they refer business to, the answer has been no. And the answer is kind of a yes in South Carolina. And I believe Virginia too. I mean, there's different caveats. There's still kind of a requirement for the lawyer to assess, does this impact the relationship, adversely impact the lawyer's ability to provide independent representation? Are there disclosures to the client? All that kind of stuff. There's requirements there, but it is permissible. And it's just an outright impermissible thing in North Carolina. And I think that's one of the things I was curious about the statute as far as Chapter 58 that talks about title insurance companies and who can issue or who can submit for title insurance. I don't know. This is my ignorance. It seems like a conflict is kind of built into the statute language itself, and I'd love to hear Martin your thoughts on that and Craig's thoughts. But I guess that's where if we maybe that first question, if we aren't going to change the answer that has historically existed in North Carolina with regards to the individual attorney owning something with title insurance and sending it on, then we get to the imputation question, which was kind of illustrated by Craig's scenario of, the associates doing the closing and they're sending title insurance to the partners, or I guess the in-house company that the partners get some sort of, return on. How does that all play out? And so with those questions kind of lingering here, and like you said, Judge, I think you said it perfectly. We want to get this right. There's a lot of different interests here. And there are a lot of people that are interested. There's 20 people watching the live stream right now. That might be a record for one of our subcommittee meetings. If you all want to hear from folks that are passionate on both sides to help you make your decision, then that's something that we can arrange for. I want to know what you all need for considering this matter, what will empower you all to make some progress on this inquiry.
Well, are the title companies all of one mind on this issue? Because I don't want to hear from 20 title companies.
Yeah, I don't know. I don't know the answer to that.
Ron, the other thing is, and this is my ignorance, I don't know enough about the back office of the title companies as far as ownership. Are they publicly traded? Are these private? I will on occasion have friends of mine who've gone in to create a title company and then want me to refer business to them, but I don't have any ownership interest in it. I just don't know. I mean, and I'm not sure about that. Is it publicly traded? If I own one share in title company ABC, does that mean that I'm forever prohibited from having a client go there, even though I don't, what I do doesn't, I mean, I guess it could create a dividend of a couple of cents, but yes, that does smell bad from the very beginning, and I get all that. And then the next issue, one thing I know it's getting a little bit broader, but unfortunately the way around this, and I see it a lot, is I have banks that tell me we own an ownership interest in this title company. We want you to use them. And so if I say, no, I can't do that, but now they have every loan I'm doing, I'm having a little piece of paper by the borrower say, I want you to use ABC Title Company. Is there something that's implicated there? Because I have knowledge that, look, I really need to be sharing this around. I don't need to be sending it to the same one all the time. Am I doing it a service, as Gina said, to the public by not doing that, by not spreading it around? And that's a little bit further than this, but that's the workaround that the lender's going to do.
I have had questions about something like that, or at least scenarios presented. I think that's very relevant, Martin.
Very common practice.
Mm-hmm.
And I would think that some of the national title companies that have, a dedicated office that's really beholden to the national company, they probably have a keen interest in this because they perhaps see economic benefit being diluted, perhaps being diluted exactly the way that Martin's described, where you've got a big lender with market power that's dictating that you use a captive title company. That's something that definitely is going on for sure.
Well, I think for the less sophisticated clients, you're putting them in an awkward position. If we allowed this, and of course, I think we'd have some requirement that disclosures be made. And now they're sitting across from an associate saying, oh, gosh, I don't want to hurt his feelings. I mean, his boss got this title company and that's where he wants me to go. And it's going to start interfering with the lawyer-client relationship, and perhaps making the client distrustful of his attorney. I think that's a consideration we need to keep in mind as well.
This may seem simple, but if I'm representing a buyer, I don't want to just get title insurance. I want to make sure my client is getting good title. Mm-hmm. So, I want somebody who is at the title company who will look at these issues and not just say, okay, I'm going to insure over this, or this is not a big deal. You may find that a client figures out post-closing that this was a big deal. And you may have a title claim, but you may also have title to some property that doesn't come with all the rights and without some of the issues that you'd rather not have. The title company just ensures that you've got good title. It only has certain exceptions that they say are applicable to the property, but there could have been more that either kind of got insured over, or maybe a lender said, I can live with that. So it does put a big burden on a potential or on a client to have to kind of wade through that morass and figure out, okay, is this really something where it's problematic if this easement, this soil road stays in place, or do I need to get the thing, out of the record or off of a survey? it creates issues. And, Martin, that's something I'm sure you're dealing with in some of the pieces of property that have been large farm tracts where people needed access over the years.
It is. And of course, the buyers that we deal with so many times now are not sophisticated. They're not corporate buyers. They are individuals maybe buying their first house, or they could be someone who's maybe not their first house, but this is not what they do all the time. And to explain to them what a title exception is and help them to understand that. I mean, a lot of this we're dealing also with a push from the real estate agents to get it closed, and the month's coming, they want to eat. And so there's a lot going on. I mean, it's as we say, it looks simple on the surface, but there's also, for what we do in this meeting, will have fairly large ripple effects upon potentially the entire title industry, as well as dealing with lenders as well. It's important, and that's why I want to make sure that we're understanding. And I know the term, I see it in the literature that was given, substantial interest. Well, of course, my first question was, well, how do you define a substantial interest? And so I don't know what that's going to mean and how that's going to apply. I mean, if we just use a smell test to begin with, having any ownership interest may potentially be an issue. But then again, you may have an ETF that you don't know has a title company in it somewhere. Are we now inadvertently causing an attorney to be in violation of the rules of special conduct because they just didn't realize that maybe one of the funds they have has an ownership interest in a title company? And that's why I don't know about how title companies, especially in North Carolina, are dealt with. What kind of disclosures do they have to be made?
I think Patty wants to say something. She's our public member.
Well, I am the public member, so I'm depending on all of your expertise to help me with this issue, and so that I could vote with a clear conscience and do what's best for the people of North Carolina and the profession that I hold in high esteem. That is, you all as lawyers. I personally would like to hear from both sides, but I may be the only one that needs that. And if so, I will depend on y'all schooling me. But I think with all these things that have been brought up, hearing from everybody, well, at least the two sides, and their take on this issue might be a benefit for all of us.
Well, I definitely want to hear from the title companies. If they're all of the same mind, we'll hear from, maybe get one to be a spokesman.
That would be great.
If there are title companies with differing opinions, I'd love to hear the 2 or 3 differing opinions, because that would be an interesting perspective also. And besides that, Brian, are there any other interested parties besides maybe some real estate lawyers?
Yeah, there's been a number of real estate lawyers. You may recall, of course, at the full committee meeting in April, there were a number of folks in attendance, and I think they were kind of on both sides. I think there are some attorneys,
Figured that.
some attorneys that would like to see North Carolina become more similar to South Carolina, and I believe Virginia has a variation. I think South Carolina is less stringent, on kind of the spectrum than there's Virginia, and North Carolina saying no with regards to just the single attorney having a financial interest and being able to act as both agent and closing attorney. But yes, I think I know there were some attorneys that don't think this is a good idea. And I think I know there was one person in particular that came up to one of our staff folks at a CLE, where this was kind of brought up just during conversation, and the attorney said, you cannot change this. This would be a bad thing for the public and the profession to change how North Carolina handles this. So I feel like we see both sides. I think it'd be erroneous to see it as the title companies want to keep things the same, but the attorneys want something different. I think there's mixed opinions from both sides. So we can already reach out to those folks that have contacted us. Like I said, we're keeping track of those that want to be informed, and we have been informing folks of the subcommittee meetings and so forth, and see if, like you said, Judge, maybe see if there's a couple of folks that could serve as kind of the representative voice for the different perspectives, because I don't think it'd be helpful to just make it an open meeting where everybody could just have a chance to talk. That would probably be, a couple days. So we don't want to do that.
Brian, to your earlier point, I think it would also be a departure from our reasoning in the prior formal ethics opinions. So
Absolutely.
if
Yeah.
we're going to change it, we're going to have to really reconcile with our prior opinions.
Yeah, we've never done that. What we usually do is when we have something that's as divisive as this, or just where there's a lot of interest, then we may kind of offer, the subcommittees have offered an opportunity to these different perspectives to say, if you wanted to submit written comments, you can submit written comments, and we'll disseminate those to the subcommittee. But understanding, of course, that being able to talk to somebody and maybe ask some questions, some follow-up questions and all that can be a very helpful thing. That's where we have, asked folks that are all interested, and it seems like there's a fair expectation that people are communicating with each other, to get folks to select somebody that could be here as kind of a representative of that particular perspective. And that is really for the purpose of this subcommittee's education and decision-making. That's the whole thing. But we want to make sure that everybody has an opportunity, particularly on this subcommittee, to hear the different perspectives, have their questions answered. And that's frankly why I did not draft a proposed opinion for this matter. I think this one is very, it's just clearly got a lot of passionate perspectives here. So we want to see where the subcommittee goes first before we start putting pen to paper.
And Brian, do you want to hear from them today at a future meeting or in July?
I think it'd be in the future meeting. I don't know that we could let anybody in today, especially just being respectful of everyone's time. We only have about 20 minutes left of this meeting. But I think we could set something up. We could even set something up before the July meeting. I know we're getting into summer schedules and all that kind of stuff, but if we could find a time and see if everybody would want to join us. I don't know that this one's going to be done by July. I didn't anticipate it to be done in one quarter, but I think it probably would be a good idea to get some of the communication going. There's going to be a lot of logistical sort of arrangements that we will take care of on the staff side. So we have just a robust meeting set for next time.
Gina Morris?
Yes, sir. Craig and Martin, probably more so Craig, do the title insurance companies have a board or an association or a society that they are all members of, so that we could go to that person like we've done with other committees to see, number one, does the industry have a unified voice? And number two, what is it, and have it come from them as opposed to all of these people with conflicting opinions about it?
They do. I think it's called the American Land Title Association. There may be other organizations, but there are links between the entities. But I will say that of the universe of title companies, there can be great diversity. For instance, let's just say there's the law firm of Patty and Gina that is like law firm X in the materials that Brian kind of shared with us from April. And they could basically be attorney A and B, and then they got associate Z. Well, then there are national title companies. For instance, Chicago Title has a national office here in Charlotte, very different kind of entity. And so the perspectives of the title companies, Brian and Tom, can be very different. So we may need to cast the net pretty broadly here and get the national perspective, get a perspective of the, Patty and Gina type firms. So we've got everybody being able to kind of voice their concerns or their interests or share their experiences with us so we can navigate this harbor that's kind of full of rocks, I'm afraid.
Well, and certainly, but my point was just that's a logical first place to go. Brian or Tom can send them an email. Hey, this is what we're talking about. Do y'all want to make a statement about it as an association? And if they say no, because our members all disagree, that's good information for us to have, I think. Second question that I have, which is probably the last time I did a real estate closing was, 1995. Do you get title insurance even if there's no financing?
Oh, yeah.
Okay.
Yeah, you can. It just depends on what they ask for. You'll ask them, do you want title insurance? And that most of the times they'll say yes. They'll say, well, what would you do? I said, you're asking an attorney whether you get title insurance or not. I mean, that's, yeah, you can do what you want to. This is how much it's going to be, a one-time charge, and then let them make the choice. And I explained to them it's to catch for potentially my mistakes, and then the title company fights with my malpractice carrier. It's an extra layer for protection for them, but they're so used to dealing with it, and they may or may not go out on a malpractice carrier or not.
Okay.
In the residential arena, it would be
Yes.
unusual not to have title insurance unless you've got a well-heeled buyer that basically can take on those risks, him or herself, and basically you got a lender usually. Again, not everybody's well-heeled. They've got to get financing to be able to make the purchase, and they will insist on title coverage. But in a corporate sense, you might have corporations that basically are not going to get a loan. They're just going to use their own corporate funds to make an acquisition. But in most of those instances, they're going to want title insurance to make sure they're basically making a sound investment in the real estate.
Okay.
Well, anybody else? Well, Brian, should we try to set something up for maybe the middle of next month?
Yeah, we've got some time before the meeting, the next ethics meeting, which will be in Cherokee. You all, I don't know if you all received emails yet, but you'll probably receive them this week. I'm guessing we've got the schedule set at this point. So we can let me take some cracks at communicating with the different folks that have expressed interest, but also see who else, like you said, Gene. I think it's a great idea to reach out to any other type of larger association that would help us just get a sense of what the voices out there want to say, and bring that all to the subcommittee really for your benefit in navigating this issue. But I'll get started on that, and I'll ask Britt to contact everybody for their availability. We might go ahead and set that for. I'm thinking that might actually benefit from having like maybe just call it a 90-minute meeting. I feel like there might be a lot of conversation, and so I might ask her if that's all right with you. I know sometimes an hour can feel dreadful, but sometimes an hour goes very, very fast. And I feel like if we're having multiple voices, we might benefit by just blocking off that extra 30 minutes to be sure that we can capture everything, and we'll just kind of go from there.
Well, I'm thinking reaching out to the trade organizations, and also if there's a Craig Lynch elsewhere in the state who has a different opinion, but who specializes in this area, that would be a good person to hear from.
Yeah. Yeah, I think having from everyone, like I love it. Martin, I remember when you came up and you asked me if that you might be interested in participating in this. I love that because we've got, Craig and Martin, you're in two different parts of the state, very different practices, but there are some of these common things. We have these principles that exist in the rules of professional conduct. And frankly, this is one of those things that, while very specific to real property issues, there's always a ripple effect with every ethics opinion that we have. So that's where it's good to have kind of the diverse perspective that we have here on this committee. So yeah, I'll reach out to folks, Judge, and we will try to set something up for I'd say mid-July.
I'll offer this up as well. It sounds like Martin may have some people that are basically positioned like law firm X in the text that you provided, Brian. There are people that I know in the trade who are not affiliated with law firms, but who are title insurers. And I'm happy to maybe identify one of those or two of those, and maybe we can look at the list of the people that have expressed interest, Brian, to make sure that we've got a full universe of perspectives, because it's not a one-size-fits-all situation, in my opinion.
Right. Absolutely.
All right. Motion to adjourn.
So moved.
I've got my marching orders.
Gina's seconded. All in favor?
Aye.
Aye. None opposed. Motion carries. See you in July.
All right. Thanks, everyone.